Make sure to like, follow, and subscribe to our podcast.
Listen, do what you gotta do to keep us around, okay? Welcome to episode 8 of Off the Cuff. I'm Matt Butler.
I'm Darren Chohan.
Now, we're joined here by a special guest tonight, Devan Munch. But before we get into Devan and his practice, why don't we talk a little bit about the Super Bowl?
That game was great.
It was outstanding. For 2 weeks, just in the anticipation of this game, you know, it was. I was really thrilled, and I was excited to watch it. Did you check it out, Dev?
Yeah, it was great. Hell of a halftime show, too.
Halftime show was pretty good.
I think, okay, we're going to talk about halftime shows. I honestly think, for me, my top of all time, that one.
No. You're being serious?
Yeah, why not?
Think about it. Think about this, like a halftime shows you've watched. You think that was the greatest of all time?
I have watched some pretty good ones, and remember, I was in New Orleans live in 2002 watching that one, which upset you a lot because I didn't tell you about that.
Yeah.
And this one still tops that. And I was not there live.
Do you think that was the top of all time?
It's up there. Didn't you say your favorite was Maroon 5?
Yeah, like your suit? No, man, it was because it's just maroon.
Anyway, it doesn't matter.
But clearly it was Prince in Miami singing Purple Rain while it rained on him.
Fine. I mean,
no?
You're going to go all meta. Singing Purple Rain in the rain.
Facts. Anyways, whatever.
Okay, so last episode, we covered off common law property rights.
Yeah.
And we realized after the fact that perhaps it was a little complicated and
a little technical.
Yeah. And so I think we left off a little bit and we didn't close the book, I don't think. So I want to get into just a little bit on how you as a common law spouse can protect yourself. And the biggest tool you have in your toolkit as a common law spouse is a cohab agreement, or often referred to as, you know, the old language is prenuptial agreement.
Yeah.
You often hear marriage contract. There's lots of different words for this agreement. But the best thing about it is that it enables you to contract out of provisions of the law. And you can circumvent certain provisions. Not all, of course. I mean, you don't want to talk to your lawyer about that if you're getting a lawyer to do it. But there are definitely ways to protect yourself. And, you know, what's the most common thing we see and biggest problem we see in common law relationships?
It's property regimes.
It's always property.
But more specifically, the home.
Yeah, right. And the home is so unique because married couples and same-sex couples now or married persons get protection under the Family Law Act for the home that they live in.
Yeah, because it's deemed a matrimonial home under the Family Law Act. Yeah.
If you are a common law spouse, you do not get that protection because you're a spouse, but not a spouse for the definition of that area of the Family Law.
Not a married spouse.
Correct. And so the way you fix that is you contract out of that provision of the Family Law Act. And so what you can do is protect yourself with a document that's living and alive until you change it, that you get access to the equity in the home that you've contributed to.
Especially if they're long-term relationships.
Yeah, because it's like a set it and forget it, right?
Right. That's a perfect way to put it. And then also what you can put, which is going to touch upon, you know, Devan's practice, is that you can even release or waive your rights to people's estates.
Oh, yeah, that's a good point, because the wills often are made in tandem with these marriage contracts and domestic agreements. Yeah. And so why don't you tell us, Devan, then a little bit about what you do?
Yeah, I'm in the litigation department at Weaver Simmons, and a big part of my practice is estate litigation, capacity litigation. Oftentimes, estate litigation and capacity litigation, they're used interchangeably. Most people refer to capacity litigation as estate litigation. They're different. Of course, you had Marissa Sarrazin on a previous episode. She discussed the difference between powers of attorneys, right, while the person is living, and then the wills kick in when the person passes. So essentially, it's broken up into those two areas, right? And different litigation for, and some of the same, but different litigation in the two different realms.
And so would you say we can classify, you can look at this in two ways, right? Pre-death litigation and post-death litigation, I think is probably
a good way to
exactly.
look at it.
And Marissa did a really good job explaining the solicitor side of things.
Yep.
And I think from what I'm hearing from you tonight, we're going to get a glimpse into the barrister side of things, the litigation side of things. So on that note, I think we should take a break.
Yep.
We'll hear from our sponsor and we'll get right back into litigation with Devan. When can you trust your trustee?
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
So we talked a bit about how your practice sort of separated into sort of pre-death litigation and post-death litigation. So what kind of issues are you seeing pre-death?
So when we're talking about pre-death, of course, we're talking about powers of attorneys. So the two, power of attorney for personal care, power of attorney for property. So the power of attorney for property, of course, you're dealing with decisions of that person's property, the management of that, right? When you're dealing with the power of attorney for care, you're dealing with their health decisions. Most of the litigation is often centered around power of attorneys for property.
Right.
Right.
Not surprising, right?
No.
Mismanagement of funds,
Mm-hmm.
those kinds of allegations. If you're looking to remove an attorney who's been appointed and be replaced, replace yourself or replace with someone else who's more suitable for the role.
So are there reporting requirements for these attorneys? Or like the trustee or whoever's acting?
There are not reporting requirements, but you're obligated to keep records of your management of that person's finances. So, but you can be compelled to pass your accounts. So there's no obligation. Passing of accounts is essentially presenting an audit of your management of that person's property to a court for it to be formally passed. An audit would be, the assets as of the date you started, any liabilities, investments, and then the day you stopped, or maybe up to a current period, right? What those assets, liabilities, investments are on that date, and basically everything in between, right? All the transactions. So it really presents if you have to present those accounts, should present a complete picture of how you've been managing, how an attorney has been managing that person's finances.
Right. So how does someone have to be compelled to pass accounts?
You'd have to bring an application.
Okay.
So there's no requirement to pass the accounts as an attorney, but someone can bring an application, perhaps an interested party, right? They could bring an application to compel an attorney.
And so what does that, there's a relationship there, right? So that attorney has a special relationship and a duty and an obligation to the person they're managing the funds for, right?
Exactly. It's a fiduciary duty.
Okay. And
right?
what does that
to act in their
mean?
best interests. So the decisions have to be made in that person's best interests.
Okay. And then is it fair to say then if an interested party feels or believes that attorney is not acting in the best interests of the person, then an application to remove them for a breach of that fiduciary duty that you just said, is that kind of the natural progression of the litigation in that regard?
Yeah, exactly. If you believe, right, that there's mismanagement or that decisions are being made that are not in the best interests of the person who's granted the power of attorney. And we can even apply this to the power of attorney for the person, right? So if decisions, like healthcare decisions that are being made are not in the best interests of that person, well, then that could be grounds for bringing an application to have them removed.
This is something that a lot of family members become involved, right? Where power of attorney sometimes are family members, and then this person who's sort of requesting a passing of accounts or maybe wanting to remove the power of attorney or the attorney. Oftentimes they're family members, right?
Yeah, it is oftentimes family members. That's simply because the person appointing, when you're granting your power of attorneys, you're typically looking for someone you trust, right? Someone who's close to you, someone you believe will make the decisions on your behalf in your best interest. So you're oftentimes looking to family members.
Right.
It's not always the case. You could be looking to close friends, but oftentimes it is family members. And like you said, oftentimes if people are looking to challenge, right, a power of attorney or the attorney's management,
right,
that is also the same nature. It's family members, right, because they're close with that person. Right.
So it can get rather contentious then and pretty emotionally charged.
Yeah, it's very much not far off from family litigation.
Yeah, I feel like we see a lot of that inter-family fighting.
Yeah.
And this sounds a lot like that.
It's very much in our realm. Yeah.
What about somebody, this kind of, as you were talking, brought me to a couple points that I wanted to ask you. First, what if there isn't a power of attorney? Like what
That's a good
happens
question.
there, right?
Yeah, so when there's not a power of attorney, it depends. If the person's still capable, right, of granting power of attorneys, well, then they can grant power of attorneys. And it's as easy as that. If there's any kind of question as to their capacity, there are capacity assessments. So there are registered capacity assessors that can perform these assessments. So it could be as easy as that, right? If the person is capable, well, then they're capable and they can grant one. They can choose who they want to be in that position.
But if they're capable, that means they can manage their own funds and make their own decisions. That means anybody who may have an issue with it, too bad. Correct?
Yeah, and they can make their own decisions.
Right.
But it'd be to appoint someone in the future.
Okay.
Right. And then what about the situation when, you talk about capacity, right? And so you're in this, I think what you would see more likely is a person who is deemed to be not capable by a capacity assessor. And we'll put a link down below there is a list of Ontario registered capacity assessors. So you can find somebody if you're in that. But, they've gone to see this capacity assessor. There's no capacity to grant a POA. And now you're stuck because there is no POA. There is no capacity to grant a POA. What does that family do?
Then, yeah.
So then if they're incapable, another assessment, if they're incapable of making decisions for personal care, and then if they're incapable of making decisions of their property, well then at that point you'd be looking at a guardianship application under the Substitute Decisions Act for someone to be appointed in that role. So the difference is, right, of course, power of attorneys, that person can pick who they want. Right, they can pick alternates. The problem arises when they haven't granted those power of attorneys and they become incapable of making those decisions. A guardian ought to be appointed to make those decisions on that person's behalf.
And once the guardian's appointed, they sort of make decisions as an attorney would under a power of attorney, correct?
Exactly.
Okay.
It's a little different in that the public guardian and trustee is involved on the application. Right, so it's on that application, you have to include the public guardian trustee. They have some input. There's plans that are set in place. There's a management plan for the property, and there's also a guardianship plan for personal care decisions.
And this is all done, you keep saying application, just for the listeners and viewers, you're talking a court application, I assume?
Court application.
Okay, yeah. And so, again, recommended when you're in this situation, at this point, when you're in this, I think our baseline is, you should probably go seek out an estates lawyer and just to get knowledge of where you're at, because we've talked to Devan now about these issues, and it seems to be that it can be very confusing as to which avenue you're in, the different stages of capacity, and we haven't even got to what happens post-death. So I think at this point, we should probably take a break.
Yeah.
And after the break, we'll get into post-death litigation, and we'll see what happens when you have estate trustees and then those requirements and get into that.
Sounds good.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
So, before we get into law stuff, I really am excited to announce the launch of our Instagram page because
Pretty great.
unlike these guys who are much younger than me, I'm just getting into
Much
the world
younger.
of Instagram. Much younger.
So much younger.
Compliment to you. They don't need to know how old I am. But I'm learning a lot and, learning how to post on Instagram, learning how to do reels, which I just learned about.
Yeah, welcome to 2017, my man. Holy wow.
Really? It's not been that long?
Longer?
Oh, God. Okay, so on our Instagram page anyways, Off the Cuff by WS, we just ran a contest, gave away some Sudbury Wolves
Yeah,
tickets.
some Wolves tickets. Yeah, that's pretty cool.
So that's cool. So congrats to our winner, and you can check out our Instagram page to find out who won. And stay tuned on that because we're planning on giving out more swag, more stuff, bigger contests, and, hype train. Let's go.
It's pretty cool.
Now, I guess we got to get back to law and reality.
And reality. All right, so someone's dead now.
Not you.
Not me this time.
That's good.
Pretty sad.
Yeah.
So we've dealt with the pre-death. Now we're looking at someone's died. What type of litigation are we looking at now?
Yeah, so that estate litigation, you're looking at potential will challenges, removal of estate trustees now, not attorneys. There could be predatory marriages, also passings of accounts, same type of thing with as attorneys for property.
We talked about predatory marriages last week a bit, eh?
Probably a topic we should dive into. We can talk about it a little later.
Yeah, okay.
So when you talk about will challenges, what exactly are like types of will challenges?
Yeah, so a couple types of will challenges could be for undue influence, right? So in that circumstance, it's someone who is putting pressure on the testator, the grantor of the will, so much so that they can't make their own decisions, right?
Right. So
It
basically,
rises to that level.
right. So they made the will not on free will.
Mm-hmm.
Okay.
So with a will, right, you're looking to the testator's intentions all the time. So when something brings into question the testator's intentions, like undue influence, where it's someone else's intentions, that could be grounds to set aside a will.
And so, like, the basic example of that is, you have somebody who's a beneficiary, like a child or a brother or a sister, somebody who's really dictating to that person who's making the will, who has all the money, where the money should go, effectively, right? Like that's like it's not at that point, it stops becoming about the testator or the person granting the will. It becomes about
The beneficiary's
intentions.
Yeah.
Right.
And that's
Which is not what a will
problematic.
does.
Right. Okay. That makes sense to me.
Yeah. And there's also, we've talked so much about capacity with Marissa and now with Devan. So I'm sure there's an avenue that you can challenge a will based off a lack of capacity potentially.
Yeah, exactly. You can. So those are also pretty common, right? The person has to be of sound disposing mind to grant a will. So there's a big legal test. We won't get into it, but it's often the basis for challenging a will is capacity.
And that is the capacity at the time of the person signing the will.
Exactly.
So if somebody has a question about that person's ability to have made the decision for all the parts of the will, that's what you're talking about at that point, right?
Exactly.
And so we get back into those capacity assessors and how important they are.
Yeah.
And why it becomes so important to seek counsel and to seek just help to make sure that you are approaching it, as Devan said, it's a pretty complicated legal issue that you probably, as listeners and viewers, don't want to be navigating on your own.
No.
And recommend that you do get independent legal advice and talk to a lawyer about that, because it's challenging, both if you are the one, I would say, challenging the capacity of that individual who had signed the will, or, being the estate trustee dealing with that will.
Because it's also difficult because the person's dead. So it becomes quite difficult to sort of gauge the capacity.
That's a really good point.
Right.
Yeah.
So,
Yeah.
The evidentiary basis must be a high threshold.
Yeah, exactly. You're looking at other things, right? Obviously, you can't have a capacity assessment.
Mm-hmm.
You're looking at medical records. You're looking at the lawyer's notes, if there was a lawyer who drafted the will, right? You're looking at their notes, the questions they've asked. You're looking at evidence from family members, close family members around the time that they granted the will.
That's actually a really cool point that I hadn't considered, is going back to then lawyers' meeting notes.
Yeah.
Because that would be a really good starting point to find out, like Marissa was talking about it, right? We asked her, how many meetings do you have with these people to figure it out? And that's such a good transition into what Devan does, because, you paper the file as a lawyer, and that's a really good, I just never thought about that. That's great, because you would want to see what the lawyer had taken notes, the questions they've asked. That's eye-opening.
Yeah, they're very important in will challenge cases, for sure.
Now, we talked about, when someone's the attorney or has the power of attorney to deal with someone's assets, and they have a fiduciary duty to the incapable person to manage their funds. They can't mismanage the money. The suspicious transactions, we can bring applications, but it's similar to an estate trustee as well.
Yeah,
right?
So an estate trustee has a fiduciary duty to the beneficiaries of the estate.
Right.
So anyone who has inheritance under the estate, they have a fiduciary duty to those people to act in their best interests. So oftentimes that means they have to, administer the estate properly, give those beneficiaries their proper distributions, right? After everything's all said and done, right? Taxes are paid and debts are paid, right?
And is there a similar mechanism, I would assume, like the passing of accounts for estate trustees as well?
Yeah, exactly. So a beneficiary is entitled to a formal passing of accounts.
Entitled?
Yeah.
Oh, so wow. So you don't even have to bring it. You have to bring an application for it.
Yes, you.
Okay, you still have to bring an
the
application.
beneficiary
Okay.
would have to bring.
But
an
there's no
application.
the trustee wouldn't be able to then say no, I'm just not doing it.
I'm not going to do it. Yeah,
Okay.
exactly. Oftentimes they might provide an informal accounting,
Right.
Mm-hmm.
right? But if the beneficiary is not satisfied with that, there's still questions left. They could bring a formal application, and they're entitled to do that.
And then does a judge review the accounts?
A judge will review the accounts. Yeah.
Okay, and then is it when you say
If it gets to hearing,
right?
right?
And
If
so
the accounts are agreed upon,
Right.
Well, then it
Right,
may not
so
go before a
I
judge.
see, I see.
Yeah.
And if it goes to a judge, then the passing of accounts is essentially like a judge signing off on, reviewing the documents and saying, okay, I am satisfied on the evidence that this trustee has done their job.
Exactly.
Now let's say the
It's a
estate.
big undertaking.
It's a huge undertaking, because now let's say the estate trustee has not done their job correctly. What happens then?
Well, their transactions, right? They'll be if they can't show where money's been, they can't properly account for their management. Well, then they run into issues, right? You could be held personally liable for that.
So you can be held to be personally liable for the mismanagement of the estate funds.
Yeah.
Oh wow! So then you're gonna have to pay some of that. So what happens? Is there a civil action then? Would someone sue on behalf of the estate, or
You could bring an action
okay?
in tandem with the application to pass accounts.
Okay.
And then presumably alongside of that is the application there to remove that person.
Right.
Yeah.
Usually. I
Similar.
would
Yeah,
assume.
you'd be looking for that relief for sure.
Right. Yeah, it doesn't sound like a fun job, hey? Being a state trustee.
Well, it's just you have so much responsibility.
Yeah.
Like you have the fiduciary duty. Just like you said, you have to act in the best interest of the beneficiaries. And if you have multiple beneficiaries,
Well, then
and
you're
a,
stuck
and a
going
large
between
estate,
everyone.
and you're having to manage a lot of funds or a lot of monies, and it'd be complex.
Yeah, that's why it's very important when you're making a will to pick someone who you think would be capable of filling that role.
Right.
Now, I know that our listeners and viewers will want to know this question because it's something I want to know. We touched upon it with Marissa a little bit, but I didn't get the answer really. I don't think I want it. But I want to know, do you get paid to do that job? Because it sounds, honestly, if I'm being honest, sounds miserable.
Sounds onerous, yeah.
Yeah, you do
you get paid?
Yeah, you do get paid trustee compensation, and it's basically it's calculated on a tariff basis. So a percentage of the estate.
Oh, okay.
Yeah.
Okay.
Yeah. So it depends on the transactions and the value of the estate. But you do receive compensation if you claim it.
There's some solace in there.
Okay, I was going to say, it could be worth it then. Depends on the estate.
Could be. Or could be not worth it, too.
Yeah, very much so.
Last time you and I talked, I get fired up about, like, case law.
Case law and different
cases. Yeah. My chicken coop I go back to. I just
you
love that
love the
case.
chicken coop
Love that
case.
case. And so today, I was really hopeful that Devan was going to give us some fiery case law. And what do you got for us, dude?
I have one case. It's pretty good. I think it'll meet your standard. It's
I hope so. It might, as long as it has some element of chicken coops or something like that.
The likelihood of that is quite low. In any event,
Okay. Guaranteed
all right.
chicken
Continue
coops.
All right. Fine.
So this case, it's McGrath and Joy.
And we'll put the link to the case below.
And essentially the issue before the court was whether to probate, so prove a suicide note as a will. So.
And so, okay.
Pretty heavy. Well.
Yeah, that's deep. All right. I'm interested, though. I'm interested.
I'm pretty locked in.
Because that, I think, you get into probably a whole host of issues. So a suicide note, handwritten, presumably.
Yeah, so it's a holograph will.
So that's
right?
that's the term that you use. Okay.
Exactly.
So what happened?
The question, so a holograph will, first and foremost, is it's an exception to the formal requirements of a will, right? So it simply just has to be written by the testator and then signed. So you don't need the two witnesses, right, to attest to the signing, and courts will probate these holograph wills.
Sometimes I think you like napkin will, right? You hear that.
Yeah.
Sometimes
Yeah,
you
you've
just
heard,
handwrite it on a napkin and call it a day.
Yeah,
Okay.
exactly. So in this case, there was no dispute that the testator had written this will,
Mm-hmm.
and no dispute that he signed it. The issue was whether he had capacity at the time he granted this suicide note will, whether he had capacity to grant a will at that time.
Okay. And so now this person is dead, and you have the beneficiaries of his estate. Like, who are the parties to this litigation? Like, who are the...
So it was an application brought by the deceased's stepson.
Okay.
So he brought an application to have that suicide note approved, right, as the last will and testament. So why did he do that? Well, because it's the deceased had a previous will, which was also a holograph will, but this suicide note was more favorable, right, to him.
The stepson.
Yeah, exactly. There are other parties involved, but
That's the gist of it.
Mm-hmm.
And so...
Yeah, so what was the finding? What was the court's finding?
The court actually found at the trial level that it was not proven. He didn't have capacity to grant a will at that time.
And what were the reasons that he didn't have capacity?
Well, there were circumstances which called into question his capacity. So there was lots of evidence from family, from close relatives, that he had suffered from alcohol and drug abuse. That abuse was greater in the 6 months to his death. And there was also evidence that he had been abusing alcohol and drugs on the night of his death. So that was the significant factor.
And so they had actual evidence, and I presume you said at the trial level, this was like a full trial with evidence and testimony and all of that. That's what happened here. Okay, and so the trial judge makes a finding of fact that because this guy was using drugs and alcohol leading up to his death, and then on the night of his death,
Right.
that was sufficient to demonstrate that he may have had a lapse in capacity when he made the holograph will?
Exactly. Yeah. The stepson tried to adduce medical evidence and expert report, but it was inconclusive that he had capacity when he granted the will or the suicide note.
And we've just recently learned that the Ontario Court of Appeal has reversed this decision, right?
Exactly.
So I think, why don't we take a break? And I am pumped to hear about this because...
Yeah, what happened? Yeah.
Yeah, when the Ontario Court of Appeal weighs in, you know that it's going to be a serious issue. And the cool part about that is that now it's going to form a part of the law in the province of Ontario because the Ontario Court of Appeal has spoken on it. So let's take a break. We'll hear from our sponsor, and we'll dive in to the Court of Appeal.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Before the break, you had mentioned that the lower court's decision was reversed by the Ontario Court of Appeal, correct?
Correct.
So what happened there?
So the Ontario Court of Appeal essentially found that the lower court erred in finding that the testator did not have capacity when he granted the holograph will.
Oh, wow.
That's a big deal, I think, eh?
Yeah. So that would mean that in Ontario now, courts will recognize suicide notes as holograph wills potentially.
Well, courts did so in the past.
Okay.
So it's not necessarily new, but it just reinforces that that courts will accept holograph wills, suicide notes in particular, as a valid will,
Subject to capacity.
The
And so
capacity,
and that's what the Ontario Court of Appeal was dealing with, right, in this case.
Exactly.
And so, like, what did they base their decision on to get to that result that you just told us about?
So what they did was they reapplied the test for capacity to grant a will, sound disposing mind, and came to the conclusion, or the finding, that the testator did have capacity when he granted that holograph will.
And so for our listeners and viewers, just so you're aware why this is a big deal, is that the Ontario Court of Appeal is the highest level of court of the province, right? And so that highlights the importance, I think, of what Devan's been getting at this whole episode, is how important it is to have your affairs in order, or at least consider it, right? To go seek that appropriate legal advice to make sure you get your, manage your affairs, get your powers of attorney done, get those wills done if it's appropriate for you, because you don't want a situation where you end up with your estate being litigated at the highest court in the province, right?
Yep.
And so, on a side note, we've talked about the suicide note, and this has been a fairly heavy topic, and so we just want to make sure that if you know somebody that's struggling with these issues, if you are, we have a link. We'll put a link below to some resources that you can access, because these are real issues that people deal with, and we're cognizant of that. But we thought it was very important to highlight this case because of what it meant for holograph wills and the establishment of that. And when the Ontario Court of Appeal speaks about it, it's important for people to know.
I couldn't agree more. I'd like to thank Devan for joining us today. We really appreciate having your insight today, man.
Thank you for having me.
I'm always, I say this every time, but like,
Always amazed by what our colleagues do.
yeah, because, you know, we practice in our little corners, and, you know, you and I do the same kind of work, so we're aware of what's going on. But, you know, just down the hall, Devan's doing something completely different, and been great to, it's really great for us to hear what goes on in this building sometimes, and the wealth of knowledge and expertise that we have here. So
we really appreciate having you
really
on.
appreciate you taking the time to come talk to us.
Now, next episode, we're going to take the viewers and listeners on a bit of a ride.
Oh, where are we going?
We're going to take them through an entire personal injury file, from accident to judgment, what you can anticipate.
That, I think, is going to be...
It's going to be interesting.
Interesting, because you're driving a car, get in an accident.
Where do you start?
What do you do? Where do you start? And you're hurt, right?
Exactly.
And that's nerve-wracking. That comes with its own host of challenges. So, good idea.
I think it's
You're full of good ideas. You do this all the time to me.
I'm so good.
I don't even know what you're going to say.
Like, I don't even have anything on this iPad. It's just.
I know. It's a blank screen, right? There's nothing there.
No. So we'll have a special guest next episode, and that will take us through that. So thank you for joining us. I'm Matt Butler.
I'm Darren Chohan.
See you next time.
Make sure to like, follow, and subscribe to our podcast.
Listen, do what you got to do to keep us around, okay?